Hello, I'm Ronnie Eldridge. Welcome to Eldridge and Company. On June 25th, 5 justices of the United States Supreme Court took the heart out of the Voting Rights Act of 1965. My guest to talk about what happened is Myrna Pérez, the deputy director of the Brennan Center's Democracy Project. She co-authored a report released just a few weeks ago called If Section 5 Falls, New Voting Implications. So welcome.
Thank you for having
Myrna.
me.
And what are the implications of this sad thing?
Well, as you indicated, the heart of the Voting Rights Act was cut out. Section 5, known as the preclearance provision of the Voting Rights Act, was created to ensure that those jurisdictions that had the most egregious racial history would be prevented from enacting election law changes unless that change got a clean bill of health. The Supreme Court did not strike down Section 5, but they did strike down what's known as Section 4. That's where it designated who had to follow these rules under Section 5. And so effectively that means that Section 5 is inoperable in the jurisdictions that used to enjoy its protections.
But they said that because it quoted statistics and things, because it based on statistics from earlier on, from 65, was it, or something, that they were no longer relevant in the cases.
One thing that I found very...
so where was that formula? It's going to ask.
The formula is created in Section 4. That was the part that was the part that was struck down. But to be very clear, Congress reauthorized the continuation of the Voting Rights Act of Section 5, including Section 4 of the part that designated who got covered by it. And in doing so, it had about 20 hearings, had 90 witnesses, had 15,000 pages of documents where they reviewed the record and decided that the Section 4 needed to continue as it was created. So while it was a reflection of an earlier reauthorization, it is not true that there was not a careful consideration by Congress and a careful determination that this was something that Congress wanted to continue as it was drafted. And one of the things that I think is also really important is that the Constitution, the 15th Amendment, makes it really clear that Congress is the one that gets to decide how to combat racial discrimination in voting. And one of the most upsetting aspects of this decision is the failure to afford Congress any deference when the Constitution specifically says that its determinations get deference.
And the irony of it, this activist court majority who has come to power saying that they're against activist judges, right?
There's a lot of critique on that front. I mean, this was second-guessing a policy determination of Congress. And this wasn't just something, again, that Congress, blew through. They studied it over a period of 11 months, and it was passed overwhelmingly by bipartisan groups.
Unanimous in the Senate, right?
98-0.
98
Pretty close, as close as you can get.
I just want to get one thing straight before we move on. We say that the Section 5 was the section, but it was Section 4 that had the statistics that then named the districts.
Yes, it does. It's the formula that was used, and then through regulations they decide when you apply that formula who gets covered.
So all that information was split between 5 and 4?
It's in Section 4. It's designated what sort of criteria have to be met in order to get what they call covered.
And in Section 5 says there's no longer any protected districts.
Section 5 is the part that says how preclearance operates. So Section 5 is a part that says if you are a jurisdiction that has been covered under Section 4, you are not allowed to make an election law change without getting approval from either a 3-judge federal court or the Department of Justice that the change that is being made is not going to be discriminatory.
Right. So we're left with?
We're left with Section 5 that is effectively inoperable. Congress needs to go back to the drawing board and needs to reenact a coverage formula based on whatever guidance they can get out of the very meager and mere 24 pages. I mean, that's one of the things that I hope your audience walks away with. In about 24 pages, the Supreme Court did something monumentally.
Have they ever done anything as large as that? By overpassing major legislation?
I mean, I think that's hard. You'd need to ask a court historian. But what I do think is very clear is that we as Americans are proud of our Voting Rights Act. We are proud of the legacy. It is celebrated. It is necessary. We all learn about it in school. It is a reflection of the promise that we make to Americans that when they step in the ballot box, they're going to be free from racial discrimination in voting. And in 24 pages,
it's gone.
It's gone.
So are we now assuming that because of the Republican majority in the House and almost in the composition of the Senate, that the indignation isn't going to be large enough to go ahead and redraft a substitute?
I think it's a mistake to talk about this in partisan terms. I think we're talking about the Voting Rights Act, which again is a celebrated and historic part of our country. I think there is bipartisan recognition that discrimination still exists today and that we still have more work to do on the promise that we make to Americans. And I am hopeful that there will be able to be a bipartisan solution on this. I know that folks are already talking to Congress members about it. I think we as voters need to demand it. We need to demand that voters get the kinds of protections that they need in those jurisdictions that have problems.
So those demands will most likely get stronger as we see what the ramifications of this action were.
That may be possible. I also think it's possible that folks, that Congress, Congress just did this in 2006, right?
Yeah.
They don't have to go back that far. They know, they have a very good sense of what is needed and where the problems are.
The state of Texas has already moved.
That is right.
To do what?
The state of Texas has indicated that their photo identification law, which was blocked by Section 5, I was one of the litigators in that case, is going to move forward. And right now, the court has, in very technical terms, vacated the order which stopped it, and so now it's just a matter of the technical process of getting it.
So in the future, if somebody goes to register, they're going to have their ID
when they go and vote.
Right. And that ID has got very strenuous requirements.
Texas is considered to be one of the strictest. There are very many people that think it's the strictest in the country. You can register to vote with your gun license, but you cannot vote if you have a University of Texas driver's student ID.
It's so frustrating when you can't find rational.
It's hard. I think it's very hard to say that justification was anything other than politicians trying to manipulate the rules of the game to prevent some people from participating and others from doing so.
So in 2012, the Voters' Rights Act was a very important vehicle, wasn't
it? The Voting Rights Act.
Voting Rights Act.
Right.
So let's just describe some of the things that were protected under it.
Okay. Well, it blocked a redistricting practice in Texas, which the court found was intentionally discriminatory. And that's really important because a lot of people think that sometimes things happen by accident or people weren't aware of the outcome. The court made a specific judicial finding that it was intentionally discriminatory against minority voters. It also blocked the photo identification law that we were talking about. In Florida, it curbed some of the restrictions that happen with respect to the omnibus bill that made it harder to register people to vote, that cut early voting, that blocked the voting the Sunday before Election Day. And in South Carolina, it was part of a vehicle by which the South Carolina photo identification law was interpreted such that it would end up not really having a dramatic impact on people because it was interpreted as allowing anybody with a reasonable impediment to obtaining a photo identification law to be able to vote. And so it had a really good outcome because in the course of the trial proceedings, that was how the state was arguing it should be interpreted. And when the court pre-cleared it, they said it should do so on that basis. So it had a really good positive impact. And the other thing I'd like to point out is we don't know how much, we can't quantify how much it did without having to go to court because would-be discriminators know that they're going to have to go through this process and they're going to have to demonstrate that it's not going to have a discriminatory impact. And we have very good statistical ways of trying to predict that there are a lot of people that don't even bother because there's a deterrent effect, and that's one of the things we cover in my report.
Is it a shocking thing to you that instead of trying to make voting as easy as possible, so many legislators try to restrict it as much as possible?
I do think that's disappointing. I think it's a one of the best things about our democracy is that we have a robust and participatory system, and our democracy is tarnished when we have rules that prevent certain people from participating. And one of the things that I think was a big misstep on the part of this court was the failure to recognize that discrimination still happens today, and we still need protections in order to make sure that everyone has free and fair access to our democracy. And it is my hope that people will demand that Congress get together quickly and act in a bipartisan and transparent manner and pass a new coverage formula so that we don't have voters go unprotected for too long.
So what's the future for you and your project?
We're going to keep working. We're going to use the tools that we have available to us. We'll bring cases under state and federal constitutions.
So you have to follow what's happening in every state.
We do. We do that as a course of business. But some of the tools left over are, again, state and federal constitutions. There's also what's called Section 2 of the Voting Rights Act. That is national in scope, and that allows people to challenge those practices which deny a community or a person of color the equal opportunity to be able to elect their candidate of choice. It's not an effective substitute for Section 5. That's another thing we cover in the report, because unlike Section 5, you are basically stuck challenging a practice after it's happened, whereas Section 5 stopped it before it happening.
That was a very important point.
That was very important. And the other thing that Section 5 did was it put somebody on notice that it happened, because you had to file something with the Department of Justice or with the court so people would know about it. Whereas in Section, whereas now we could have people making changes right before the election, and voters might not find out about it until it's too late. So we are left with tools that are not going to be as effective, but I'm very optimistic. We're a very dedicated voting rights community. We're going to work very, very hard to protect voters, and we hope that voters, again, demand that their Congress members take action quickly.
So does the Brennan Center then have different groups around the country that you work closely with?
That is right.
It's a whole network?
Yes.
Is it basically groups that are affiliated with law schools?
We're civil rights organizations, good government groups. We have lots of folks that understand that voting is central to meeting their objectives, and so we're very pleased to have national partners that are like the Brennan Center doing this kind of work, and we also have state partners that are keeping track of what's going on.
Were you always interested in doing this? How did this all happen? I mean, you have to be passionate about this, I think, to really do it.
No,
right?
I mean, I feel like I'm extraordinarily lucky. I get to do a job that I feel privileged to do. I get to make a modest.
How did it all start?
I was 19 years old, and I was working for a voting rights organization in San Antonio, Texas, which is where I'm from, and I was working on a redistricting matter, and I found the jurisprudence around the Voting Rights Act so interesting and so hard, and it had like a numbers basis, and I've always liked quantitative stuff, and so I got the bug and have been interested in doing it since.
And then you went to law school?
I went and got a policy degree from Harvard first, and then I went to law school.
Did you go to the Kennedy Institute?
I did.
You did?
I did.
So that was the other question I was going to ask is, here you have very dedicated, committed attorneys who know the Constitution and know the rights. And then out there you've got a body politic. The connection between political activists and you, or the need, the sense of it. Do you find that frustrating, or do you find, how do you bridge that? How do you get the political activists to go ahead and do it?
I think we need public education. We need public education. I am very lucky in that I get to talk to voters, pretty much every day. I get to talk to election officials who I think work extraordinarily hard and have a lot to do, an incredibly important job, and they have to do it with very little resources. And, and I think that when you have voting right groups and voters and election officials able to come together and say, we need to guarantee that when people go to vote that they'll be free from racial discrimination. I think those groups working together can put a lot of pressure on Congress. And they can also put pressure on their state governments. One of the things that the Brennan Center does is track legislation. We track restrictive legislation, but we also track positive legislation. And in the last legislative cycle, we've seen a lot of both. We've seen, states try to pass restrictive laws, but we've also seen a lot of states do some very pro-voter things.
Yeah, that's it.
And that's, that's very exciting. And I think that speaks to the kind of concern and the kind of appreciation that many Americans have for their voting. And one of the things we need to do now is to make sure that we eliminate all the unnecessary barriers to eligible Americans participating. We have a policy proposal called Voter Registration Modernization, where we try to leverage existing technology to get more eligible voters on the rolls. And there are lots of different aspects of it that make a lot of common sense. Like when you go to a social service agency, why is it that you have to fill out a piece of paper after you've already given them the information that they've plugged into the computer, and then that person has to take it and then mail it, and then at the election office they have to type it in? Why can't the computers just talk to each other? Those are the kinds of changes that we like to see.
Is there a group that works with New York State and New York City?
There are. We are.
I mean, it is amazing to me in this state that has so many progressive people in it that we have such a regressive system for elections. It's just incredible.
Yeah, I think the switch back to Lieber machines took a lot of people for a loop.
Not only that, it's so hard to get on the ballot. I mean, here we have
New
York
ballot
City
is
has
very
campaign
poorly
finance.
designed.
The ballots are poorly designed. It's hard to get on the ballot. It's then the whole. It's hard to vote. We don't have early voting other than absentee ballot. It's amazing to me. And part of that's reflective, I guess, of the legislators who make these rules, that some of them are, I know I get more political than you want to get, but they're incumbents and they don't want to change the world, right? So why bring in more people? I think that's my...
Well, I mean, one nice thing about a democracy is that, you know, the people are the one that ultimately have the power, and it's just a matter of making sure that the people are educated and that they're able to get their voice across. Right. And that was why the Voting Rights Act was so important, is because it was a really important line of defense when people, when states, when jurisdictions would try to manipulate the rules of the game, so certain people had less of an effective voice.
Are there are the states that were listed in Section 4 still the most egregious?
That was certainly there's certainly a lot of people that think so. There's certainly a lot of record that demonstrates that. But again, that is not the legal standard that the court should have applied. And that's the standard that some people would want. This legal standard the court should have applied was whether or not Congress had done its job of carefully considering everything. And there was an enormous amount of record to try and demonstrate that the jurisdictions that were covered under Section 4 still had continuing need for it. And there, you know, there's been a recent study of some folks indicating that the jurisdictions that are covered under Section 4 were ones that have had restrictive legislation that can't be attributable to anything other than race. So I think, you know, we could have, you know, debates about whether or not this one is worse than this one, but that's not ultimately the question. The ultimate question is, was Congress reasonable in deciding that it needed to continue Section 5 in those jurisdictions? And I think that answer should have been an overwhelming yes. But because it was not, we're stuck in a point where we're going to have to find tools that are not going to be nearly as effective to keep us where we were and to prevent us from sliding back.
Do we have to watch to see if the Department of Justice goes after Texas now with its a photo ID, its ID related?
There are, you know, there are a lot of ways in which someone could do that. There's already been a lawsuit filed against that case.
Right.
You know, the Department of Justice is one group of folks.
So a private lawsuit could do it. The Department of Justice could also do it.
Right.
I see. And then are there other avenues?
Well, I mean, again, there's
that's basically.
No, but there's also, again, state courts. I mean, I'm sorry, state law, either state statutory law or state constitutional law. There's other aspects of the Constitution. Those two groups you were talking about, voters and the Department of Justice, are under Section 2 of the Voting Rights Act, but more people could arguably challenge it under the Constitution or under another provision. So, you know, voters will be protected. It'll just be much more resource intensive and much more difficult. And one of the nice things about Section 5 was that it prevented gamesmanship, because you know, it was something that Justice Ginsburg noted in her opinion. Discrimination can be a multi-headed hydra. You go and you cut off one head and then another one comes up that you also have to combat. And Section 5 disincentivized that, because, you know, they try, if somebody would try to do one thing that was problematic, that would get blocked, and if they try to do something else, that would still get blocked. Yes. It wasn't like you had to.
But this way, it's each individual action,
right,
which takes not only
time,
energy, time, and money.
And people need to know about it before it's too late. One of the things we are concerned again about is legislation people know about. just, reporters hear about it, the voters hear about it, it has to occur in the political process. Changes that can happen at the hands of an election official, outside of public scrutiny with little public notice, those are things that people are going to need to watch out for, and we need voters and their advocates, and we need the media to be paying attention to those things and being willing to sound the alarm when they see something.
And some people have said since then that the more these regressive measures are passed in some of the states, the more the backlash is going to be, so that people will be motivated to really act.
There's certainly a large school of body of thought that
it's
thinks
like
that
we're deputizing. We want to deputize everybody to become inspectors and watching what's happening.
Well, if everybody was motivated enough to get out there and vote, and I think we saw some of that in the 2012 election, right? We saw people standing in line in the face of burdens and boredom and frustration, and people were still waiting in very long lines because it was important for their right to vote, and they weren't going to have people squash it.
But the sad part is that the next election cycle is for the House. It doesn't have a presidential part to it, so.
I think it's
a pretty important thing, because those are members that should be responding to this and writing the new legislation, right?
Right, and it's certainly, elections are certainly important. We do have a problem with drop-off, but I do think that there's some national sense of outrage, and not only that, but also a recognition that the right to vote is something that we need to be vigilant about, right? We need to not take it for granted. We need to not presume that it will always be there. And so my hope is that voters will make sure that they're educated, will make sure that they understand the importance and go out and vote even in those off-year elections.
So what are your objectives as far as increasing voter access?
Well, one of the big things, like I said, we're working on is our voter registration modernization proposal, and the idea is to use technology to get existing eligible persons on the rolls that are not currently on the rolls. And there's differing ways to do that. One of them is what we call electronic registration, where you either can register online, or you can, when you go to a social service agency, instead of having to fill out a bunch of pieces of paper, it just electronically gets transferred. Automatic presumes that people can't say no, or they can't opt out, or there's not a check. So it's not automatic as much as it's electronic once a consenting adult says, I am eligible and I'm willing to fill out the pieces of information. The other thing we're trying to do is to make your vote portable within your state. It really doesn't make a lot of sense when we have these statewide voter registration databases, why if you switch counties, you have to go and register to vote again, and if you show up to vote on election day, you're out of luck if you've switched counties and didn't tell your election office. We're looking for election day corrections. So if a voter goes and finds themselves not on the rolls on election day, that they have some mechanism for casting a ballot that will count. And again, with these online systems, people should be able to say, I've changed my address. My name is misspelled. It needs to be spelled this way.
But it should still be someplace that they can
can access, that they can change, that they can utilize. And I think especially with the problems that we are experiencing with young people drop off, like these are good ways to meet people where they at. Today is the anniversary of the 26th Amendment, right? So the 18-year-olds were able to get their right to vote today. And I think it's really important that we are able to meet people where they're from. And young people are using apps for just about everything. We need to make it technologically attractive for young people to register to vote.
It's a national phenomenon that counties control the registration and elections?
We have a system set up where the federal government has authority to set certain regulations for federal elections, but states set eligibility. So when you go to any state, county to county, there'll be sometimes similar rules, but they're often different, and they certainly differ across states. You have some states where you can register to vote on election day, some states that have a closing book day of this day. So we do have a kind of a patchwork of systems.
And are there some states where more money, public money, goes into financing the election day operations as opposed to other states?
I'm sure that's the case. Some people some places are more resourced than others, and one of the things that we're studying is the effective resource allocation on election day. Things like how many voting machines does a jurisdiction have, and how many people do they have to service? They matter when it comes to how long of a line is, right? How many poll workers do they have, and how many does each poll worker have to serve? Those things matter on election day. And I think we ask our election officials to do a tremendous task task, but they could be better resourced. They should be better resources. You know, we shouldn't get democracy on the cheap. Like, this is what makes our country great, and we need to be able to make sure that everyone has the resources they need to do the job well.
The Brennan Center has a very good website, and so does the Democracy Project as part of the Brennan Center. It's called what?
At www.brennancenter.org.
And if people look it up, they can find all kinds of information.
They certainly can. They can find more about our voter registration modernization proposal. They can read our brief in the Shelby County case. They can see some of the public writing that we've done on this issue and others. If you're interested in campaign finance, and it sounds like some of your audience is, you can see a lot of work about our New York public funding proposals.
We do the blog, which has articles that have been written by other people about this whole thing. So you can really become fully conversant and very knowledgeable by looking at it.
You certainly can.
Yeah. Well, I think the citizens of the country, and certainly the citizens of New York, are very beholden to you, and I hope that you have much success in the future.
Thank you so much for having me.
Thank you, Myrna Pérez. Thank you. So. If there are any people you'd like to hear and topics you'd like us to explore, please let me know. You can write to me at CUNY TV, 365 Fifth Avenue, New York, New York, 10016, or you can go to the website at cuny.tv and click on Contact Us. I look forward to hearing from you.